Good afternoon to the folks on the East Coast and good morning to the folks out west. My name is Erin Lacey and you're tuning in to Managing and Challenging, the new GE disclosures. This is the last, number 5 of our 5-part webinar series on navigating gainful employment. So moving along, my name is Erin Lacey. I'm a partner in the higher education practice here at Thompson Coburn. Thompson Coburn is a law firm. We have about 400 attorneys and we've got locations in St. Louis, DC, Chicago, LA, and other types of places coast to coast. Our higher education practice does a lot of different things. I usually divide it into 3 buckets. We provide regulatory counsel on federal, state, and accrediting agency laws and standards. So we do Title IV, Title IX, ADA, consumer information, federal financial aid, all that kind of stuff that applies to institutions of higher education. We offer people regulatory advice, and gainful employment clearly falls in that bucket. We assist folks with post-secondary transactions, whether you're a for-profit or a nonprofit. People go through all kinds of different transactions at different stages, do contract drafting, policy creation, help folks design compliance systems, those kinds of things. And then we also represent institutions and student and employee and other types of litigation, and we assist folks with government investigations and administrative proceedings. So Department of Education program reviews, proceedings with your accreditor or with a state entity, the VA, something like that, we'll get involved. Before I was at Thompson Coburn, I spent 4 years in-house at a post-secondary institution that had 24 locations and an online division and oversaw all of their regulatory, compliance, and strategic development initiatives. And then prior to that was an associate and attorney in another post-secondary education practice group at a law firm in Washington, D.C. So here's the whole schedule. If you haven't been tuning in, we've done 5 webinars, and today you see we're on the last one, again, managing and challenging the new GE disclosures. This is the presentation outline. As always, I'm going to spend just a couple of minutes going through the GE timeline. I know that that's been a repeat feature, but we think that's really important, and we want that to be something that sort of is internalized for folks who've been attending all the way through. And then we're going to get into the heart of the order, content of new GE disclosures. So we'll go through these disclosures that are going to be required and really get into the nitty-gritty of what they're about. And in many cases, they're different from the stuff that was out there in 2011. And it's important if you intend down the road to challenge these things to understand how they're constructed and the underlying data that's being used to create each of these disclosures. So we're going to, like I say, go through those in some detail. Then we'll talk about distribution of these new disclosures and how that works. And then finally, the mechanics, to the extent they are currently known, for challenging these disclosures and the kind of things you want to be thinking about. And as always, at the end, we've got some GE resources for you. All right, so the gainful employment timeline. 2015, that was last year. Obviously, these are the main things that happened. You had the regulations became effective July 1. On July 31st and October 1st, institutions reported a great deal of data for prior award years, 08-09 through 14-15. In November, the department for the first time made available the opportunity for institutions to go set up their SAIG mailboxes and to enroll in the new Data Challenges and Appeals Solution Service. These are the things you need to do to receive specifically the completers list from the department, and we talked about that in detail a couple of weeks ago, that you will have an opportunity to challenge. And then the DCAS system is the department's new platform for challenging various types of data. We're going to talk about that a little bit later today as well. End of the year, December 31 of last year was the deadline to complete GE transitional certifications. I know the department is still working through that and verifying those with institutions. You may have gotten some sort of error message and you may be working something out. If for some reason you did not take that step and provide a transitional certification and you think you need to, you should go ahead and do it. Find out, run it to ground, and make sure you've got that box checked. This year, the story, the narrative of 2016 is the challenges to the debt-to-earning rates, and like I said, 2 weeks ago we talked about this in greater detail. You've got your completers list. that we expect to be disseminated mid to late spring, although they have not come out yet, and I see things getting pushed further and further back. But maybe by late spring, institutions will get a completers list at some point after that. And remember, there are fixed timelines here that take place between each of these events. So if the completers list gets backed up, everything will be pushed back necessarily because of these regulatorily imposed timelines. So the first thing is the completers list in spring, and then later in the summer, maybe late summer, early fall now, we would expect to see the first round of draft rates come out, and that's the point at which institutions could start doing challenges to the loan debt information, included with the draft rates, as well as taking first steps towards an alternative earnings appeal based on the earnings information distributed with the draft rates. But that's the story for 2016 is, you're going to get this information relating to your first round draft DE rates, and you're going to have opportunities to challenge that data. In 2017, now if the whole process I was just talking about in 2016 gets backed up, it's possible that we won't see the final debt to earnings rates, the first round of final rates, until maybe late winter, even early spring of next year, right? But the topic we're going to be talking about today, the new GE disclosures, by law, institutions are expected to comply with those effective January 1, 2017. Right? So now the department may come out with guidance and talk about sort of the enforcement timeline and allow institutions some time to get things into place. It's possible the department could get backed up in getting out the updated GEDT or Gainful Employment Disclosure Template. But as a matter of law, the new regulations that govern the new GE disclosures become effective January 1, 2017, and that won't change. And the old disclosure regulations, which are still in effect right now, will, as a matter of law, sunset. So we will move into this new piece with regard to the disclosures effective January 1 of next year. Again, that's what we're going to focus on today is the new GE disclosures. So let's talk first about their content. Like I said, I want to go through this in some detail. So content of the new GE disclosures. What information must be disclosed? One of the interesting points here is that the precise combination of disclosures is not yet known. It's going to be determined by the department and reflected in the GEDT when they distribute it. And they discuss in the regulations and talked a great deal in the preamble to the final regulations about the fact that they're going to conduct consumer testing to determine the best disclosure mix. They actually say in the preamble, we don't expect that every potential disclosure that we talk about in the regulations will be included and in fact disclosed to students. Now, I don't know if that's true or not. Part of me feels like we may see them wanting you to disclose all the data. But the fact of the matter is they have not said yet what exact combination of the data we're going to talk about today will actually be in that first GEDT come January 2017 in the template, and as a consequence, what you'll actually have to be disclosing. They also have made clear that it could change year over year. They suggest that they wouldn't want to change it too much because they don't want to confuse consumers, but if they put something in the mix and then they continue to do consumer testing, turns out that consumers say, this isn't useful, maybe they'll take it back out. They also have hinted at the idea that they could include things that aren't even in the regs right now. There were some folks who said, well, you should be disclosing information about the GE certifications or information that's in your PPA, things like that. And though that is not in the current regs, the department at least suggested that they might take those kinds of things into consideration if they felt like down the road that would be very useful information. Now, I think that's speculation at this point, sort of extreme speculation, but it just goes to the extent to which they viewed these disclosures as somewhat fluid and being affected by these the consumer feedback and the specific mix changing potentially year over year. In some cases, and this is another important point, in some cases the disclosures will be based directly on data, or you will be disclosing data that you reported to the department, right? So this is a data point. It's, the length of the program, for example, is one of these things. And you will tell the department how long your program is, and that's what gets disclosed. There's a whole other bucket of data this time around that the department's going to calculate, right? So they're the things that you just provide and get passed through and become part of the disclosure. But then there are all the things that the department, based on information you've previously reported, that they're going to crunch numbers based on formulas and the regulations, and they're going to actually create some sort of rate or data point, and then that's what's going to be disclosed. It's important to divide these, and I'm going to talk today when we go through the content, I'm going to divide it into these two buckets, and here's why. It's because the second bucket, the stuff that the department calculates, that's the stuff you get to challenge. Right? Because they don't have a challenge process in place for you to challenge the information that you provided and it's just passed through onto the template, right? Like program length. The assumption is you got that right. And if you need to correct that or if there was some error, you can just go and correct it, right? But the information that they're calculating, they appreciate that these are calculations they've done, and so you will have some opportunity to challenge that data. So that's why I've divided it today into those two buckets. So let's talk first just about the stuff that you're going to provide directly and that would potentially be passed through into the disclosure. A lot of this stuff looks just like what you saw in 2011. So occupational data, primary occupations by name and SOC code that the program prepares students to enter, along with links to occupational profiles on ONET, right? And remember, we're going to talk a little bit later about how you can, just an aside here, we're going to talk later about how you can package some of this information. You know, the department year over year has worked pretty hard to change up the template to add new features that it thought was beneficial or would create additional clarity. We're going to talk later about how you can present them on your website and, you know, how prominent links need to be and that kind of thing. But just like if you listened in last week when I was talking about the student warnings, you know, and this is pretty much my advice when it comes to any kind of disclosure. Remember, it's pretty rare that laws or regulations are written in a way that they restrict you from adding any type of context to a disclosure. And occasionally that does happen. But here, for example, I mean, you could add language in or around the link to the GEDT, and in some cases, you actually have the opportunity to create language that goes into the disclosure template, right, where the department has enabled that functionality. Take advantage of that if it makes sense to, right? But if you think that there's something, and the example I'll give is, and the reason this comes up is because when I was in-house, and we did this first piece in 2011 for our disclosures, occupational data. We had a concern that when we plug the zip code in, because you guys who've done this before, you know what happens is your program has zip codes. You plug those zip codes into the Department of Labor's website, and it spits out these SOC codes and says, these are the occupations that we would expect would be related to a program with this zip code. It's possible that it could spit out occupations that are not typically obtained by your graduates, right? So we created contextual language around the disclosure that said, look, this is how this works. You know, it's a mechanical process. We input a zip code. This is what a zip code is. It spits out a SOC code. This is what a SOC code is. But you should also consult with Career Services to discuss the extent to which our students and graduates are actually getting these particular jobs. Right? And that's all in the spirit of better and more accurate disclosure, but it also allowed us to mitigate potential confusion that might be created by a profession that, or, you know, a job that got spat out by the Department of Labor's website. So that's just an example, and there will be other examples, and the department's given a little more, created some additional functionality now to help schools deal with that particular issue. But as a general note, when you're doing these disclosures and you're thinking about how to present this stuff, just like with the student warnings last week, keep in mind there may be opportunities for you to package these disclosures and to provide, again, contextual language that will make for a better disclosure and eliminate confusion. All right, so occupational data, program length. Interestingly, there is no mention of the concept of normal time in the new GE regulations. Now, that definition of normal time and that concept still pops up in other places relating to other FA consumer information laws. But you'll remember the old GE disclosures, there were a number of things that were calculated on or revolved around this idea of normal time. For the new GE disclosure framework, the department has booted that concept, and they just are going with a flat concept of program length, and you will see that when we talk about how things are calculated later on. And that's something they get from you. So you'll be reporting to them what is the program length in calendar time, and that could be weeks, months, years, et cetera. Program hours, so you're going to tell them what are the clock or credit hours, or equivalent related to your program. You may say, well, what would be equivalent? Well, the department is contemplating the possibility of competency-based education here, and they talked about that specifically in the preamble. I saw some of the folks registered for today's session are associated with institutions that do a lot of CBE. So if you have competency-based education programming, at least in the sort of direct assessment model, you may have a program that has no clock or credit hour total associated with it. And so the department in that case is allowing for institutions to try to come up with some equivalent measure that they could use for purposes of disclosures. Total cost, so that's the cost for tuition and fees, as well as the cost for book supplies and equipment. I've put in parentheses normal time. I probably should not have done that, but that's for someone who completes your program in the standard program length. Again, the department does not use that concept of normal time in the new regs. Placement rates. So just like under 2011, the department's expectation is that you're going to have to disclose any rates that any state or accreditor requires you to calculate. And a lot of the qualifications here are consistent with those that were previously attached to the 2011 disclosures. So if you're required to, for example, calculate rates for both your state and an accreditor, or maybe even a state and or two states and an accreditor, et cetera, the department says you have to disclose all of those, right? So you don't get to pick and choose. If any of those guys at the state or accreditor level is requiring you to calculate a placement rate, you're supposed to include that in the GEDT, or at least that is one of the, quote, potential disclosures that the department could require you to disclose. Again, they have not settled on the exact mix yet. My guess is placement rates will be in there. They consider it a very important data point. Another sort of wrinkle when it comes to placement rates, if you're required to calculate a placement rate at the institutional level, meaning if you calculate a placement rate for your whole school, the department's expectation is that you will take that methodology that is prescribed by the state or the accreditor, and you will calculate a rate specific to your program, and you will supply that in the disclosure, which is a lot of work. And that may sound pretty radical. That guidance is what was already in place with the 2011 disclosure. So if you haven't been doing that, just understand that that is going to be a requirement under the new framework as well, and it's something that you need to do. It's unclear to me, although my guess is it is highly likely this will be the case. Presently, the department has created a new space in the most recent disclosure template for institutions to provide the regulators methodology. In other words, you're supposed to describe how they go about calculating the placement rates, and most specifically, the department's interested in any exclusions that may apply. So when you calculate the placement rates for this regulator, you're allowed to exclude certain categories of students. That's the kind of thing the department really wants to be in there. It's not explicit in the regs, the new regs, as to whether or not schools will still be required to provide that methodology information, but my guess is that that will be the department's expectation. And I would take a little time to make sure you get that right. If there are any accreditors or states out there, you might also consider packaging something for schools to use so that everyone can use the same consistent information. So to the regulators, I would say maybe think about that. I'll be chatting with the folks at NASAPS later this year, and this is something I intend to recommend because I think it would make it a lot easier for schools so that they're not all trying to come up with some sort of paragraph describing the regulator's placement rate methodology. Total enrollment, the total number of individuals enrolled in the program during the most recently completed award year. Title IV participation, so of that total enrollment number, the percentage of those folks that received a Title IV loan or a private loan for enrollment in a program. That addition of private loan is pretty interesting, particularly given that it's sort of characterized as a Title IV participation number. The other thing is that's going to mean if you are offering some sort of payment plan and you have a question as to whether or not your payment plan is officially a private education loan under the law, you may need to reach that determination so that you can get this calculation right. Programmatic accreditation, whether the program is programmatically accredited, and if so, the name of the programmatic accreditor. Most folks disclose that already, and that certainly can have a market advantage for you, so that's something presumably most folks would want to include. And then a link to the College Navigator website. So those are the items that you will provide to the department and essentially will pass through, and if they decide to include that in the new disclosure template, those items would be included. My apologies. There's one other very significant item, actually, that falls in that bucket. Licensure and certification information. So, and I think this is something that schools are going to have to be really careful about, and I would encourage you to give this some thought. So the department wants you to indicate whether your program satisfies educational prerequisites for professional licensure or certification. First of all, just determining that can be a challenge in some states, and I'll use an example. I mean, I know that there are some schools that offer, for example, a substance abuse counselor program. And my experience has been that in a lot of states, they regulate that profession, and folks, before they can actively participate, they have to get some sort of licensure. But often there are lots of different combinations of both education and experience that a potential applicant can put together and use to obtain that licensure. And it can be complicated if you're an institution looking through that to determine whether or not you satisfy those educational prerequisites, right, or some combination of those educational prerequisites. The other thing is, wherever you talk about that or disclose that to students, you need to be really careful, right, because you don't want them to get confused or felt that they were misled. So the first challenge will be just determining whether your program satisfies these educational prerequisites for professional licensure or certification. And this overlaps. This is an exercise you also needed to go through in connection with your GE certification, that transitional certification, because this was there was essentially a very similar certification that you had to make. So whether the program satisfies the prerequisites for professional licensure or certification and then there's two buckets, in each state within the institution's metropolitan statistical area. That is a government concept. You can look up your MSA. It's basically your sort of a municipal region, right? But the first question is, do you satisfy these requirements in each state that is within your MSA? And it's possible if you're, say, in Memphis, you might have 2 or 3 states that are within your MSA, Arkansas, Tennessee, and Mississippi, right? And the second bucket is, in any other state for which you have made a determination regarding such requirements. And I think what the department's getting at here is, look, if you know that, say, 40% of your students are going into a state that is not within your MSA, so let's say you're located in central Illinois somewhere. I'm sitting in St. Louis, so let's say you're in central Illinois, and you know a significant percentage of your students are going down to St. Louis and into the Missouri market, which isn't that far away, but is not part of your MSA. The department is saying, look, if you've made a determination and you've already figured out whether your program satisfies these licensure and certification prerequisites in the state of Missouri, you need to disclose that as well, and that ought to be part of the disclosure template. Then the last thing they want you to say, and this is really just in the way of a canned statement, is they want institutions for any other state. So if it's not in your MSA and it's not a state for which you've made a determination, and you're not under an obligation, by the way, to make a determination so in any of those other states. So the department's just saying if it's not a state in your MSA and it's not some other state for which you've made a determination, then you need to include a clear statement that you have not made a determination with respect to the licensure or certification requirements in those other states. I don't think that means you have to list them, but I think what that means is, practically speaking, the disclosure says something like, look, these are the 3 states in our MSA, and this is what we know about those. We've also made a determination for Missouri because we know a lot of our students go there, and then a canned statement that says we have not made a determination with respect to licensure certification in any other state other than the 4 that we've listed above. And that's practically speaking what that's probably going to look like. Okay, so now we're on to the second bucket, and that's the disclosure data that's going to be calculated by the department, right? And again, the reason it's significant to split these apart is because these are the items that you will have, you will be able to challenge. Completion rates. A couple of things I also want to point out here. The first is these different types of rates, they are calculated using a variety of different cohort or student, different time periods and student groups. And it's really, and most of them are defined terms. So it's really important to appreciate that there are differences as we go through. And here, I've tried to highlight those by putting them in quotes. So completion rates are going to be calculated by the department, and they're calculated by enrollment cohort for full-time and less than full-time students, right? So you've got 2 groups of students, full-time students, less than full-time students. An enrollment cohort for an award year includes students who began enrollment in the program during the award year, right? So you're looking, a couple of things here. I mean, first of all, in terms of time frame, we're looking at an award year. It could be the most recently completed award year, for example. And then now what we're looking at is the students full-time and less than full-time that began enrollment in that program during that award year. That's the enrollment cohort. Enrollment status, whether they're full-time or less than full-time, is based on the student status as of the first day of enrollment in the program. So, by the way, again, the department's going to do these calculations, but it's important, just like with the DE rate calculations, it's important for schools to understand how they're being put together so that you're in a better position, if you think it's appropriate to do so, to challenge them. So there are two equations I'm going to put in front of you here. The first one is for full-time students, and you'll see, so they're taking, this is the completion rate equation. It's the number of full-time students in the enrollment cohort, right, who completed the program within, and they're going to do it at two different places. They're going to do it at the normal program length, 100% of the program length, and 150% of the program length. And then that's over the number of full-time students in the enrollment cohort. So really what you've got here is, first of all, for full-time students, you've got two completion rates, right? You've got a full-time completion rate based on 100% program length, and you got a full-time student completion rate based on 150% program length. Similarly, we've got two equations for folks who are less than full-time, right? And here you see the only real difference is instead of 100% program length and 150, we've got 200 and 300. As you know, that for a less than full-time student is essentially the same as sort of normal time and 150% of normal time. But because they've moved to this program length concept, for a less than full-time student, the normal time to complete would be 200% of the program length, and time and a half would be 300% of the program length. So this is the equation, again, that the department's going to use to calculate the two different completion rates, potentially, that you could have to disclose for less than full-time students. Now, again, the department, and this goes back to their very first comments on program mix, I think they appreciate that 4 different completion rates might be too much and might be confusing. So they've set out in the regs that they're going to calculate 4 different completion rates, 2 for full-time students, 2 for less than full-time students, and then they may make some determination as to which of those 4 is really most useful to include in your disclosure template. Withdrawal rates. So completion rates is number 1. Withdrawal rates is number 2. They're going to be calculated for all students who withdrew during the enrollment cohort. So again, we're using this concept of enrollment cohort when it comes to calculating withdrawal rates. Here's your equation. And once more, you'll see that they're going to do this potentially for 2 different time frames. So they'll calculate a withdrawal rate, right, for students who withdrew within the 100% of the program length, which a lot of us, again, would call normal time. And then also, they might calculate and potentially include in the disclosure template a withdrawal rate for students who withdrew within 150% of the program length. So here's your calculation for withdrawal rates. Loan repayment rate. There's been a lot of discussion in a lot of different quarters about loan repayment rates. In the context of HEA reauthorization, there have been some folks on the Hill, congressmen who've introduced legislation that advance different concepts around repayment rate and different formulas. In the context of the current neg-reg proceeding, a lot of folks on the line will know that there's a negotiated rulemaking ongoing right now that concerns various phases of loan discharge, and in the context of that conversation, a loan repayment rate discussion has arisen. There is a loan repayment rate that is in the new GE disclosure regs. It's already sitting there, right? Even though some of these other conversations are contemplating a different, potentially a slightly different formula, there's one in the law, and this is what it is. So for borrowers who entered repayment on Title IV loans during the 2-year cohort period, so we've abandoned the enrollment period now, which was used for completion and withdrawal rates, and now we're talking about the 2-year cohort period, which is a defined term. If you were on for earlier presentations when we talked about calculating DE rates in the regs, the 2-year cohort period right, for the 14-15 award year is 10-11 and 11-12. So it's a 2-year period that occurred during the 3rd and 4th award years prior to the award year for which DE rates are being calculated. I know that's a very complicated thing. The easier thing to just understand is, for example, for this first go-round, the 14-15 award year, the 2-year cohort period represents 11-12. So when they calculate loan repayment rates for purposes of disclosures, they're going to be looking at borrowers who entered repayment on Title IV loans during that 10-11, 11-12 period. And they're talking about potentially calculating loan repayment rates, or they will calculate them, I should say, for all borrowers, for borrowers who completed their program during the period, and for borrowers who withdrew from their program. So potentially you could get 2 different loan repayment rates, really. Or 3, I should say. You'd have the entire cohort of borrowers and then just those who completed and just those who withdrew. And in every case, it would be for folks who entered repayment during that 2-year cohort period. Here is the equation. Number of borrowers paid in full plus number of borrowers in active repayment over number of borrowers entering repayment. Now, if you go to the regulations, several of these concepts are defined. Borrowers paid in full, borrowers in active repayment, and they get into some detail as to what that means for someone to fall into each one of those categories. Just because that was a little more in the weeds than we wanted to get into today, I have not included that in this presentation. But if you go to the new GE regs, you can find those additional detail on those concepts. Median loan debt, right? So the department, as you know, in connection with the DE rates that we talked about in the last 2 or 3 weeks, they're already calculating median loan debt. They're going to do it for purposes of disclosure as well, for the disclosures, and they're going to use the formula for that's the same formula they've used to calculate the median loan debt for the transitional DE rates. Why do I say transitional? Because they're going to be looking at folks who either completed or withdrew during the most recent award year. So remember, under the standard calculation, when you're calculating median loan debt for purposes of DE rates, you're looking at folks who completed during that 2-year cohort period or an expanded 4-year cohort period, depending on your particular situation. But what that means is typically you're looking at the debt associated with folks who completed your program in 10, 11, 11, 12. When the department calculates the transitional rates for each GE program for this first go-round, for when they're doing the 14-15 award year, they're actually going to look at the debt for folks who completed the program during the most recently completed award year. For the purposes of median loan debt, when you're talking about disclosures, as a matter of law, they're always going to be looking at the most recent award year. And they're going to potentially calculate loan debt for three different numbers, potentially. One would be just for students who completed the program during the most recent award year, and that would presumably be identical to your transitional, to the median loan debt associated with your transitional DE rates. For students who withdrew during the most recent award year, which is totally different from what they're doing for the DE rates, right? This is a completely different population of students. And potentially they could do a consolidated number based on all of those students, so both folks who completed and folks who withdrew during the most recent award year. Mean or median earnings. Okay, so these are going to be obtained from SSA using a methodology that is similar to that used by the department when they're calculating mean and median earnings for the standard DE rate calculation. But in this case, again, they would do it potentially for varying student groups. So students who completed the program during the cohort period. Cohort period, again, is a defined term, so we're back to that 2-year cohort period or 4-year cohort period, whatever is appropriate. And students who completed, well, that would be the same as what's calculated for your DE rates, right? Because when they're doing the DE rates, that's what they're looking at, is they're looking at the earnings for people who completed during the cohort period, right? But they also could calculate and pull earnings for students who withdrew during the cohort period, or they could do a consolidated number, a mean and median, for the entire thing, right, for folks who completed and withdrew. So there's some overlap with the DE rate calculations, but there are also new numbers that could be calculated. An annual earnings rate, this is finally something that's simple. This is just your most recent annual earnings rate as calculated in connection with the DE rate process. And then finally, your program cohort default rate. You know, when the department was going through the rulemaking for the 2014 regs for these gainful employment regulations, there was a lot of discussion over whether program cohort default rate should be included and particularly whether it should be considered as an eligibility factor. In other words, just like the DE rate, right, should the program cohort default rate be a data point they look at and use to determine whether a program can continue to be eligible or not. Ultimately, the department, for a variety of reasons, decided not to make program cohort default rate one of the eligibility factors when they're looking at programs. But what's interesting is sort of when the press came out and that happened, there seemed to be, I don't want to say an assumption, but in the way the literature came out and the discussions were occurring, it was almost as if the program cohort default rate had gone away. It was diminished in importance, but the department is still going to calculate it, and you may still be required to disclose it. And my expectation is that this will be one of those data points that the department requires institutions to disclose because they've clearly established in the past that they think it is of great value. In fact, at one point, they were even going to make it one of those things that tied to your eligibility. The process for calculating program cohort default rates is almost identical to the process for calculating an institutional level CDR. In fact, I mean, it really, when I say almost identical, there's almost no variation. So I haven't put it out here. It's not that it's overly complicated, but it would have taken several slides, and most folks are already familiar with how your CDR is calculated for your institution. The difference is it's just calculated at the program level based on people in that program. If you want to look in more detail at how it's calculated, it's set out at 34 CFR 668-502, and when we distribute these slides, that's a live link, so you can just click on it and walk through it. But if you literally did a comparison, if you pasted the regular CDR regs and the pCDR regs on how to calculate these things and then ran a red line between the two, you'd see there's almost no difference. Content of new disclosure. So I wanted to go through a handful of these questions that sort of came up in my mind and that have come up in my conversations with other folks that relate to the content question. So when must the content of the disclosure template be updated? The department has, in the regulations and in its guidance, both recently and for the guidance relating to 2011, has pretty consistently held the line that you have to update the GED information at least annually, with the most recent data available for each program. And in recent years, as anyone who's had this responsibility knows, the new award year data typically is required to be included by January 31 of the following year. And that's because the department releases its new gainful employment disclosure template typically in mid to late January. So the idea is they push out the new template, and then you have to update the new template using any changes in their format and also your most recent award year data. But something I want to point out, I have seen this in departmental guidance before, and I always like to make this comment just as a practical matter. If you are only looking at your disclosure templates once a year, you're potentially exposing yourself to some risk, because every time you make a change relating to program cost or length or any other element of your program information, if you're not updating the template as well at the same time you do that, then you may at that point have inconsistency between what appears in your catalog or other places on your website and what's in that template. And the template is on your program pages, it's on your website. Going forward, you're going to have to provide it to students, prospective students, and actually get them to sign off on it. So you're going to want the information in the template to be consistent and current, at least as relates, I'm not talking about the stuff that the department calculates, right, because you're going to have to wait for them to calculate and push out the new numbers. But for those program items like the length and the cost and the name of the program, the things that you control and that you can refresh, right, and update on the template on your own, I would update those at the same time you update those things in any other publication or disclosure. Because again, if you don't, then you're going to have inconsistency, and that's just going to create potential risk and problems for you down the line. Also note, and we made this point last week when we were talking about student warnings, that in addition to those sort of timing pieces, you're also required to update the disclosure template within 30 days of receiving notice from the department that you have to start providing a GE warning. So even if in January you got it all up to speed, if given whatever the department cycle ultimately turns out to be, let's say in March or April they sent you a notice saying that you've now got to start making the student warnings, you would have 30 days to again update your template to make sure that the canned language was included. What if I offer a single GE program at more than one length, right? So you've got this exact same program, same zip code and credential, the department thinks of it the same way, but it's at two different lengths. And it could be at two different locations or whatever, but even at the same location, let's say you have two different lengths. This is addressed now in the new regulations specifically. So institutions that offer a program at more than one length must publish a separate disclosure template for each length of the program. What's interesting is under the old framework, this was really discretionary. Originally when the department put the regs out, there wasn't any allowance for this kind of variation, and then a lot of folks came back and said, this doesn't make any sense. You know, we're creating a single disclosure, but it's covering lots of different programs that are offered in very different formats and with different names and at different price points, et cetera. And the department said, okay, we get that it will make for a better disclosure if you can split these up. But you weren't required to. Under the new regs, if you offer a program at more than one length, you must publish a separate disclosure template for each length of that program. And each disclosure template must clearly identify the applicable length, which you would expect. What if I offer a single GE program at more than one location or in a different format, right? So you guys know if you've got multiple locations all under the same OPE ID, and you offer a program, and by program I mean it's the same zip code, same credential level, right? But you offer it at different locations, maybe one at a location in Los Angeles, the other in a location in New York. They may be at very different price points, right? And there could be a lot of things that are different about those populations and how the program plays out at each campus. So the department has said, and again, this is consistent with the views that finally came along in guidance after 2011, in such cases, an institution may publish separate disclosures for each version of the program if doing so would result in clearer disclosures. I've highlighted may because, again, that's different in the new regs. If it's different lengths, you must do separate disclosures. If you've got at a different location or in a different format, and by format, the examples the department uses for the concept of format is full-time, part-time, accelerated, you may publish separate disclosures if doing so would enhance the clarity of the disclosures. Each disclosure template, as you expect, if you're creating separate ones, needs to clearly identify the applicable location or the format of the program. Can I create a different disclosure if I offer versions of a single GE program under different names, at different prices, or with different specializations? So what I'm getting at here is, so let's say you offer a program, it's at the same campus. Let's say you have two versions of your program, but they're at the same location. They are in the same format, ostensibly, meaning they're both, for full-time students. They're not accelerated or anything like that, and they're at the same length. The department has contemplated those three criteria, as I mentioned on the prior slides, and said, yes, if you have versions that differ based on these three criteria, then you either must or may split out your disclosures. At this point, there is no guidance and there's nothing in the regs that talks about other types of variations, like the ones I've noted here, name, price, specialization. Under the guidance for the old disclosures, the 2011 guidance, the department seemed amenable to providing different disclosures based on these type of criteria, again, if it enhanced the clarity of the disclosure. But the current regulations don't talk about it. By the way, speaking of guidance, my expectation is between now and the end of the year, we will see a lot of additional guidance on this topic. Right now, the department is understandably consumed with getting the completer challenge up and going, and then they're going to have the draft rates to issue and the annual the alternative earnings appeals to deal with. So they've got other things on their plate, even just within the realm of gainful employment. But at some point later this year, with the January 1, 2017 effective date coming, they're going to have to start putting out a lot of additional guidance about how all of this is going to work. And I would expect that this is one of those things that they will address. Oh, another point on guidance. If you go back right now and you look at the department's FAQ page, there's a section on disclosures. I would be very careful about taking to heart anything. They have a date after each paragraph where they make a disclosure that indicates when the disclosure was made. There's a lot that was done in April 2014 prior to these new regulations even being put out even in the Federal Register, much less becoming effective. I would be very careful about taking that older guidance to heart, because presumably it applies to the old regulations that will no longer be disclosure regulations, which will no longer be effective at the end of this year, and not to the new ones. So remember to pay attention to the age of the guidance if you're looking at additional guidance on disclosures, and to look for new guidance that comes out between now and the end of the year. If I create a different disclosure template, so let's say you've got a different length of program, so you have to, or let's say you've got a difference in location or format and you decide to because you think it'll make it clearer, does that affect, or how does that affect the information that's disclosed on the template? This is really important. So if you publish a separate disclosure template, because for whatever reason you've got different versions, you must, under the law, you must disaggregate the following data points on each of those disclosures. And what I mean by that is, in other words, you've got to recalculate or make sure that these data points are accurate and specific to the version of the program on that disclosure, right? So the clock hours, credit hours, total enrollment in the most recent award year, total cost of tuition fees, books, and supplies, program placement rate, percentage of Title IV recipients for the program, licensure and certification information. So let's say you split out and you create two different disclosures for the different program links, but your creditor only requires you to calculate a placement rate for both of them combined. Well, you've got to disaggregate that placement rate, right? Because you created two different disclosures, gainful employment disclosures, and you divided them, again, based on the fact that they were different lengths, I'll say, hypothetically. And so now you need to calculate the placement rate so that it is specific to the programs to the students in each version of that program. So that's what the department means by you have to disaggregate that data. Equally important, institutions are prohibited from disaggregating the other data points that we've talked about that are on the template. So not only are you required to disaggregate these data points, they're the only ones you can disaggregate. So remember, we talked about completion rates, right? The department's going to calculate those completion rates. Even if you create two disclosure templates for each version of your program, and they're at different lengths, you're still going to have to put the single completion rate that the department calculated for the whole thing combined on both of those disclosures, which can be problematic. And I'll be interested to see if this position changes down the road, because I could see a situation where, going back to our prior discussion, let's say you've got two different locations. You're within the same OPID. One's in Los Angeles, one's in New York. The completion rates in New York might be much higher. Maybe you've got a different kind of student demographic. Maybe you've got better facilities or better faculty. Who knows? But it could be significantly and materially higher than the program that's offered, the exact same program, but offered at the location on the other side of the country. In that case, it would seem there is a very strong argument to be made that providing a combined completion rate to the students in both New York and Los Angeles is misleading, or in the least not helpful, right? Because in reality, the folks in New York are completing at an 80% rate, and the folks in Los Angeles are completing at a 45% rate, right? And it would be much better if they had that information disaggregated. But for the moment, right, so I think there's a public policy argument to be made there, certainly with regard to things like the completion rate that the department's calculating, maybe too with annual earnings and median debt. I mean, if those are materially different at two different locations, why wouldn't you want to give the students the better information? But right now, the salient point is that institutions are required to disaggregate the data that you see on the screen in front of you if you've got separate disclosures, and you are prohibited from disaggregating any of the other information. So just remember that. Do I still have to generate a disclosure template if I only have a few students enrolled? Okay, so for privacy reasons, you are not required, an institution should not include the following information if it's based on fewer than 10 students. And what I'm trying to, important point here is you're still required to generate the disclosure, but you're not required to include, and in fact you should not include, these specific data points. So again, this isn't just a thumbs up or thumbs down kind of thing, sort of with the disaggregating of data. You're going to have to pay pretty specific attention to the individual data points. So here, if you've got less than 10 students, then you shouldn't be disclosing completion rate, total enrollment, loan repayment rates, etc. Is the data in the new GE disclosures based on all students? No. And the reason I'm pointing this out, and this is something that the department has not really, in my view, talked about a lot, and I think it's an important point. So the data in the new GE disclosures, right, and in fact all of the new GE framework only incorporates information for GE students. And the definition of a student in this new framework is, as many of you know, an individual who received Title IV HEA program funds for enrolling in the GE program. So when the department's calculating the DE rates, when they're crunching all these numbers for these disclosures, when we're talking about students who withdrew, students who completed, all students, we are always talking about students who receive some form of Title IV HEA program funding. Now, that could be just a grant. It doesn't have to be loans, right? But they had to get some type of Title IV. If you have someone who was completely cash pay and took out no Title IV, they are invisible when it comes to the new GE disclosures. This is a complete departure from the 2011 framework, right? Under the old law, the disclosures, all the calculations, everything pertained to all students in your GE program. What this means is, and this is the thing that I haven't heard the department really clarify, and I wish they would have talked about a little bit more, what that means is right now, in 2016, this January, when you put together your data and you made your disclosures, that should have been for all students in each of your GE programs, because those disclosures were made under the old law, which is still in effect, the 2011 law. It doesn't sunset until the end of this year. Meanwhile, when you were reporting information last fall to the department, right, and when you're talking about all the challenges that are available to you this year for the DE rates, and you're talking about anything related to the new regs, as well as the disclosures that go into effect in January 2017, you're talking about only students who got some form of Title IV. I have talked with institutions, and I think there may be some confusion out there, and there may be folks who, when they, because last fall you're reporting information just for Title IV folks, then you turn around and at a point later, this January, when you're doing your disclosures, it would be easy to think, well, now I'm just dealing with Title IV students, but that's not the case. For the disclosures that you were creating this year and that are right now part of your disclosure templates on your website, et cetera, those are supposed to have been calculated under the old disclosure laws that are currently in effect. And for purposes of those calculations and disclosures, you're talking about all students in the GE program, not just the students who got Title IV. Let's talk about distribution. Some of this is going to seem very familiar if you were on the presentation last week. So the new GED template has to be disclosed on any school webpage containing academic, cost, financial aid, or admissions information about the GE program or maintained on behalf of the institution. Two important points here, right? The first is you're only talking about web pages that talk about the GE program. So if your landing page is just a beautiful picture of your institution and doesn't talk specifically about your program or an individual program, you wouldn't expect it to be there, right? On the other hand, if you do have web pages that are specific to the program, that's where you would need to have the GEDT information. Similarly, if you've got a third party with which you contract that creates microsites for you or otherwise creates web pages for you that talk about your programs, they also need to have that link on them. And my advice, this is sort of that lawyerly advice, if you have a contract with those guys, pursuant to which they provide you with that service, I would amend that contract if it isn't already amended for this reason, and I would make sure that they understand that they're required to do that. And I would want some sort of indemnification provision in there that offered me some protection if they fail to do it. In all marketing and promotional materials, so on those web pages. Secondly, in all marketing and promotional materials made available by, or again, on behalf of the school to prospective students or third parties acting on their behalf that identify the GE program by name or otherwise promote the GE program. So in all your collateral, right, that you make or you have someone make for you that talks about the program, in any time of advertising or promotional spot that talks about the program, you're supposed to have this disclosure information, right? Again, if you've got contracts with folks, just like with the website, creating websites, I would make sure that those contracts contemplated this requirement and gave you some protection that these third parties that are doing this on your behalf are complying with this requirement. But also I want to note again that this is only if the collateral or the promotion is about the program. So if you've just got a billboard, you know, and it just says, hey, it's got your mascot on it, or it says, you know, be a bear, be a tiger, or something like that, right? You don't have to have this stuff there, right? Because that's just about the institution. It's not specific to the program. Examples include, but are not limited to, catalogs, invitations, flyers, billboards, etc. So the department, when they're talking about marketing and promotional materials, they're taking a comprehensive view. The third place you have to distribute. So number one, you have to have this on your website. Number two, you have to have it in your marketing promotional materials. And number three, you have to, and that's all similar to what we saw under 2011. Number three, you have to distribute it directly to any prospective student or a third party acting on his behalf before he signs an enrollment agreement, completes registration, or makes a financial commitment to the institution. So if you got a gainful employment program, you got to get this disclosure, the disclosure template, in front of the student before they do any of these things, right? Okay, so is there any alternative to posting the entire gainful employment disclosure template? Okay, on web pages or in promotional materials where space or airtime constraints preclude using the entire template, schools can use a prominent, readily accessible, clear, conspicuous, and direct link to the template. I have no doubt that when the department does program reviews or other types of compliance reviews, they're going to be looking at just how good a job you're doing at satisfying these various criteria, right? And in the preamble to the regs, they even talk about if it's an air spot or a commercial, someone, if they speak too rapidly, if they read off the, you know, the canned language, but they do it in one of those really quick ways that's hard to understand, they might consider that as failing the clarity requirement here. So they are serious about not wanting this tucked into some indecipherable font on the bottom of the page or read off at lightning speed during a radio spot. Prominent, readily accessible, clear, conspicuous, and direct. The other thing is the link should take them straight to the template, not to an intermediary web page where you have all the links to the templates for all of your programs or something like that. And the department's pretty adamant about that and has been pretty adamant about that historically when they've been reviewing these websites. By the way, I will tell you there are people already at the department who, I mean, as a key part of their job function, every day they are reviewing institutional websites for gainful employment disclosures and other consumer information disclosures. And they will do what they call off-site or focused program reviews or other reviews if they find that folks are deficient. So make no mistake, the department is monitoring. Schools must identify the link as, and here's the canned language, it was in the guidance in 2011, now it's in the regs, important information about the educational debt, earnings, and completion rates of students who attended this program. How may the new GE disclosures be delivered to a prospective student or third party? Okay, so on the prior slide we talked about some variations that are available to you when it comes to web pages, marketing, and promotional efforts. When you're talking about the prospective student requirement, right, this is going to look a lot like what we talked about last week with the student warnings if you were on that session. So it has to be delivered in writing. There's no oral option here. It has to be delivered in writing. You can hand deliver it as a separate document. So it can't be packaged with a ton of other materials. It can't be stapled to the back of a catalog, right? I mean, this disclosure needs to be a separate document, right? And it needs to be hand delivered. Now, you can do it individually or you could do it as part of a group presentation. And you have to obtain written confirmation of receipt. So as a practical matter, what you probably want to do is integrate into your admissions process some means by which you get this in front of a student so that they can sign it, and then you get an actual signed copy or the original and give them a copy and get it in the student file or scanned into your student management system. You can also deliver it via email to the primary email address used by the institution for communicating with the prospective student. But again, if you do that, you're going to have to comply with the specific distribution requirements, and these are the same as the ones we saw last week with the student warning. So if you do it by email, you have to ensure it's the only substantive content in the email. You have to receive an electronic or written acknowledgement that the email was received. So you're going to have to get that from the student. You still got to have that acknowledgement. It can be electronic. It's not like they have to print it out, sign it, and email it to you. They can electronically verify. I've not seen anything in the department's guidance or elsewhere that suggests that has to be done through some sort of particular mechanism or third-party verification system. At least for the moment, it would seem that a response email would be sufficient. We may get more guidance on that You can send it using a different address or method of delivery if the initial email gives you a failed delivery response. And the department hasn't issued guidance on this yet either. They told us, and we talked about this last week with student warnings, that if the initial email attempt failed, then you could try to use U.S. mail, snail mail, for your follow-up attempts. They haven't talked about it in the context here of the required disclosures, but my guess is that they will provide the same guidance for that as well. And then maintain records of your efforts to provide this disclosure template if you do it by email. When must the institutions begin making the new GE disclosures? We talked about the effective date of the new law is January 1, 2017. So unless the department comes out with guidance suggesting that they're going to phase in the requirement or that their new template won't be available until later, which is a strong possibility, by the way. I mean, if they don't have the new template ready to go, they may say, well, just hold off until we get you the new template. But the new law becomes effective January 1, 2017. All right, challenging the new disclosures. So what if you think the data is wrong? You will have an opportunity to challenge the information that the department generates. Remember, that was all the stuff sort of in that second bucket that we talked about, completion rates, withdrawal rates, repayment rates, okay? In fact, here I've got the second bullet that shows you what those data points are: median loan debt, median or mean earnings, and the program level cohort default rate. Challenges to completion rates, withdrawal rate, repayment rate, and median loan debt. These are all sort of grouped together in the regs, and also sort of practically speaking, the department, they can all be challenged within 45 days of receiving draft data from the department. Okay, the department hasn't talked yet about how the specific process will work, but our speculation at this point, given what we know already about the completers list challenges and what they're doing at the moment, is that they'll use the new data challenges and appeal solution platform. They will probably push the information out, we would expect, through an SAIG mailbox or something along those lines, and give you the notice that way, and the department's institutions will have this 45 days. Right, to review, and then if they want to challenge, they would do it back through the DCAS platform. That's our expectation. It is unclear if median loan debt for students who completed the program during the most recent award year can be challenged twice. And what I mean by that is, if you have a transitional rate for your program, that means that they have already calculated the median loan debt for students who completed the program during the most recent award year, because that was calculated in connection with the transitional DE rates. Then if it also comes up in the context of the GE disclosures, what's unclear is if you would get two bites at the apple. There is some language in the new regs that say you can't challenge things twice, but it's not clear that it applies to this situation, so we'll have to wait for the guidance. My expectation is the department's view is going to be no, you get one shot, but it is interesting to note that this could come up twice. The other thing that's also unclear is how successful challenges that are mounted during the DE rate process would be accounted for here. And what I mean by that is, right now, you might be going back to the department, or not right now, but later this year, and challenging the debt numbers associated with students who graduated during the applicable time frame. So then let's say later on we go back and some of those same students end up in the cohort here, right, when they do the disclosure calculation. Now, they've already accepted the revised data, but my concern is, how do you ensure that the revised numbers that they accepted on your behalf when you went through the DE rate process, right, are accounted for? And a lot of that's going to come down to timing. It could be, at least theoretically, if they were doing these two things at the same time, and they approved, the revisions to some of the debt data in connection with the DE rate process, right, that you wouldn't have a chance to update those debt numbers until a point after some of the disclosure data was already being crunched. I know this is getting into the weeds and getting complicated, but the point is they're using information associated potentially with the same student in two different places. One is when they're doing these DE rate calculations, and one is when they're doing calculations for purposes of the disclosures. And if you're correcting data through process one, the concern is that the corrected data that the department has accepted is included in the calculations when they're doing process two. And I'm not clear on how that's going to happen, and I think institutions should be very concerned and pay close attention. Because it's not clear to me, just because the department has accepted your revised data, that that's somehow migrating instantaneously through all their systems and will be there and will be used in any future calculations. So I think schools are going to want to look closely anytime you have a challenge that is accepted, that whether it's with loan data or anything else, to make sure that the accepted, updated, improved data is included in any calculations associated with the disclosure process, this process of calculating GE disclosure information. Following resolution of the challenges, as you would expect, the department will send you a notice of determination, letting you know whether they accepted your information or not, and then publish the final information. And that's for all of the things in this category: completion, median loan debt, et cetera. All right, challenges to mean and median earnings. So you're going to have a shot at challenging the list of students used to pull the earnings data, right? And you get 45 days to challenge that list, just much like a completers list challenge in connection with the DE rates. You get 45 days to challenge that list. But remember, when we're doing DE rates, the list is just, it's completers list. It's just students who have completed the program during the cohort. But for purposes of disclosures, the department may also pull and calculate mean and median earnings for students who dropped, right? So this would be the first time you would go through any type of process where you might challenge earnings information associated with students that dropped. You cannot challenge the actual earnings information that comes back from SSA, but you can challenge the list. So they will send you the list of people they think should be, if they're doing completers, on that list, the list of people if they're doing drops or withdrawals, the folks who should be on that list, and you'll have a chance, just like with the completers list challenge we discussed a couple of weeks ago, in the context of disclosures, you'll have a chance to challenge those lists. We expect that the challenge process will mirror the completers list challenge process that's evolving right now for the DE rates. So again, that would be pushing things out using an SAIG mailbox, challenging through the DCAS system, et cetera. The disclosures law, so the laws surrounding the GE disclosures, recognize the opportunity for institutions to correct data and to argue for excluding or including students based on certain criteria, just like with the completers list challenges we talked about a couple of weeks ago. Here also, I should note that the department requires that there be at least 10 students in the cohort. So if you only got 8 or 9 students in the cohort, SSA is not going to provide a median or mean earnings number. It's unclear, again, how successful challenges to completers list data that are lodged during the debt to earnings rate process, how that revised data will make its way into the data that's being used to calculate your disclosure information, right? And again, just like I was talking about with median loan information, my concern is if you successfully provide alternative earnings information to the department, or you successfully get them to revise the list of folks who completed during the cohort, you want to make sure that they are using the revised and updated data when they're calculating your disclosures. For purposes of the GE disclosures, right? And it's not clear to me yet how that's going to work, and I think that's one of those things that schools are going to want to look closely at. Speaking of alternative earnings, so in the context of the DE rate process, as you know, you have an opportunity not only to challenge the list, right, that they use and they send to Social Security Administration, but you also can literally come up with alternative earnings and say, we challenge the earnings data SSA provided. I mentioned a minute ago, and I just want to clarify again here, when it comes to this disclosure process and the disclosure data, you do not have an alternative earnings option, right? What that means is, and this is where I think this is significant, so when you do an alternative earnings appeal in the context of the DE rate calculation, because that DE rates only concern earnings for students who completed, right, that means that the only time you would have a chance to provide alternative earnings would be for students who completed. The thing is, the department in the context of the disclosures is also talking about potentially pulling earnings information for folks who dropped or withdrew, right, during the period. But you're not allowed to mount an alternative earnings appeal in the context of the disclosure process. So from what I can tell, it does not appear that the schools would have any opportunity to put together alternative earnings information that would relate to students who withdrew. right? Now, you may not care about that, first of all, and it's not going to go to your eligibility, the program eligibility, but it's just an interesting note that there seems to be something seems to have fallen through the cracks here, and it may be something that schools want to pursue down the line. In fact, and I will note, not only are you not, there's no provision for alternative earnings appeal, there's actually a reg in the disclosure section that says, quite specifically, the department will not consider any challenges to the mean and median earnings calculated under this section. So what they're saying is you get a shot at the list, but again, you don't get a shot at the earnings information calculated for purposes of the disclosures. Challenges to draft program cohort default rate. So this is the very last piece. The challenge process, just like the process for calculating program level cohort default rates, the process for challenging program level cohort default rates closely mirrors the processes in place for challenging institutional level cohort default rates, right? So if you want to challenge the draft rates, they're going to push that out to you in draft rate form. So just like you get, right now, draft rates for your whole institution, you'll get a draft program level rate along with a loan record detail. Schools will have 45 days to challenge the accuracy of the data in the loan record detail report used for the pCDR. And then similarly, after your final rates come back, there are certain options that will be available to you. And you're going to recognize these if you do much with cohort default rates at the institutional level. So you'll have appeal options, and those will include the uncorrected data adjustment, new data adjustments, erroneous data appeals, and loan servicing appeals. And all of those track the same types of appeals that are available to you at the institutional level. Here are your GE resources. There's not a lot right now from the department. You can look at the preamble to the final regs, which had some useful commentary, but since that point, they've not talked a lot yet about the disclosures. They did note in their June 2015 Dear Colleague that they would be more guidance would be forthcoming. This is links to the department's guidance, and we've, as you all know, been on multiple presentations now. These are the various resources that we offer. Thanks to all that have tuned in. I wish you the best of luck with this new set of regulations. And if you have questions, please feel free to reach out. That's why we're here.